the thing is, we're all here for the same reason, because there's one thing we have in common. We respect the Constitution of the United States of America. And there's another man coming up here who's going to go and tell you exactly what he thinks of the Constitution. He's running for 4th District Congress. He's a business owner, and he's a friend of mine, Dan Sebring.
Right.
Thank you, Charles.
You know, I can't remember a time when I wasn't aware of the fact that as an American, I have the right to keep and bear arms, even as far back as grammar school. And we're talking the early 1960s here. I looked forward to the day when I could exercise my Second Amendment rights. Little did I know that in those carefree days of my youth, that the fight for that right would last nearly 40 years. Until recently, the shotgun I keep propped against the wall behind my bedroom door in my own home was considered an illegal concealed weapon. We've come a long way in a few short years in Wisconsin, and along the way, I have learned a lot more about our Second Amendment right to keep and bear arms and what it really means than I ever imagined. You know, just this morning, I was at the Summerfest Rock and Soul Run half marathon in Milwaukee, and I couldn't help but wonder, what if this were Boston? In light of recent events and emotions, this issue needs to be addressed in a calm, rational, and constitutional manner. It's time to take a look at all gun laws and regulations, both state and federal, with a clear eye towards the Constitution and common sense. It's abundantly clear that gun-free zones are nothing more than potential killing fields, and there can be no doubt that criminals and the mentally unstable can get access to firearms in spite of all the gun laws and firearm regulations. It's time to turn the power and responsibility back to where the founders intended it to be, with we, the people. Weapons bans and magazine capacity regulations are overtly unconstitutional and should be removed from public discourse altogether. In the United States versus Miller, the Supreme Court of the United States upheld the 1934 Firearms Act on the ground that automatic weapons were not the infantry standard for the military at that time. The M1 Garand was the standard then. The United States Supreme Court standard for Second Amendment protection was, and I quote, "If a weapon is any part of the ordinary military equipment or that its use could contribute to the common defense." The arms referred to in the Second Amendment are those which are used for military and public defense purposes. By that standard, not only are assault weapons bans and magazine capacity regulations a violation of the Second Amendment, but they're a violation of the National Firearms Act as well. The Supreme Court's ruling in D.C. versus Heller and McDonald versus Chicago together clarified that the Second Amendment right of all citizens to keep and bear arms. Taken together, we can see that the court has held that the Second Amendment protects an individual right of all citizens to guns relevant to self-defense or guns that bear relation to individual service in the militia at a given time. According to the Miller ruling, the militia referred to in the Second Amendment should be capable of acting in concert for the common defense. And further, that ordinarily, when called for service, men were expected to appear bearing arms supplied by themselves and of a kind in common use by the military at that time. Now in modern times, I think we can extend that definition to include women, since they serve this nation in the armed forces too. We must abandon the unconstitutional folly of weapons bans. The Wisconsin Firearms Freedom Act sends a simple message to the federal government. Wisconsin will not help you take away our constitutional Second Amendment rights. Thank you for your time.